Let me briefly introduce the panel. We are very privileged to have three editors on the American Journal of International Law to give us insights on what constitutes great international law scholarship, and to also just speak generally about the publishing process, how to first of all get your submissions selected for publication, and then some heuristics or pitfalls to avoid in the course of your writing. First, we'll start with Professor Dinah Shelton, who's professor at George Washington Law School. She's been there since 2004 and previously taught in a number of other universities, has published widely, and is also a practitioner of international law, serving since 2009 on the Inter-American Human Rights Commission, and has a very active caseload that perhaps you could talk a little bit about to what extent does international law scholarship play a part in her decision-making on the commission. Next, we'll have Professor David Stewart, who has also published widely and is also has extensive experience, having served in the legal advisor at the State Department for many years, is now a visiting professor at Georgetown Law School, but served beforehand as adjunct professor for 25 years at Georgetown. And finally, we'll have Julie Furgerson, who was for the past 2 years managing editor at AJIL and is now transitioning into a new role as editor at AJIL, and will be editing some of the sections on international decisions, contemporary practice in international law, and book reviews. So if we could start with Professor Shelton, and if you could discuss maybe in general terms the decision-making process behind selecting articles for publication in AJIL, and then again, if through the course of your scholarship you've been able to sort of take away any lessons learned for how to do it well and effectively and efficiently, and then finally, if there are any specific qualities of great international law scholarship that you could point us to.
Okay, well, let me start with submission process, because I think the AJIL is different from all the student-run law journals because it is peer-reviewed. And that means that it's harder to get into the journal. It doesn't take that many articles each year. And it requires 5 people to agree, more or less, on its suitability for publication. Everything that comes in is looked at by one of the 2 editors-in-chief to begin with. They do a kind of initial screening. And then they communicate with each other on the articles that they pick out as potentially suitable. And then they send those articles out to 3 editors, blind. So when we get the articles, we don't know who the author is, and the authors get back our comments, and they don't know who we are. And it actually works better than confidentiality in most international organizations, because you usually don't find out. And when the 3 editors review it, they're selected because they are supposed to know a little bit about the topic. They probably won't know everything about the topic, or they would have written the article that is being submitted. But the responses will come back either with no and here's why, or yes and here's why, or in most cases it comes back with this will be great for the journal once the following things are done. And so they will usually come back after a first round of reviews with suggestions for revisions. And it doesn't matter how many articles you publish, that's going to happen. I have one coming out in this January issue, and it came back with suggestions for revisions. So that's a very good process, and I always find the comments that the editors make to me very, very useful, and without exception have improved the quality of the article. So that's as much as I guess I can say about the process. I think the editors are very good about insisting that the comments get back in a fairly timely fashion, and letting those who are reviewing know if there is a deadline that has to be met in order to make comments back to the editors. So maybe if there's any questions about that before we move on. Okay, well, what makes an international law article great? It's kind of like asking Rehnquist what makes obscenity obscene. He's kind of looking at it, I don't know. But I guess I would look at it in terms of two components. One is the subject matter and the other is the style. I cannot focus on the subject matter of an article if there are spelling and grammatical errors. I just can't see what the article's about because I get so annoyed at the errors that I'm looking at. So the very basic is, don't rely on spell check. Proofread the articles, proofread them a second, a third, a fourth, a fifth time. Reread Strunk and White before you start writing any article. Much more important than how to write scholarly articles is how to write, period. And that I think is essential. Write in the active voice when you can, know the difference between adjectives and adverbs, all of that sort of thing. One irritant I have, and I know it doesn't bother other people as much, I don't like scholarly articles written in the first person. I just don't like to read, I am going to say this and I'm going to say that. I find it annoying. Other people don't. So, you can't write for everybody. Particularly when you are citing somebody on the board who might be reviewing your article, make sure that you spell their names correctly and quote them correctly, because that gets really annoying as well. Accuracy. Those who are going to be reviewing the articles are going to know the field generally. And so if you put December 9th, 1948 for the adoption of the Universal Declaration of Human Rights, or call it the Universal Declaration on Human Rights, that's going to leap out at the reader. So real accuracy in terms of citing materials is also important. But all of that is actually background to the content and topics. And I'm a bit at a loss here because I find I'm my own worst judge of my own articles. The first article I ever submitted as a first-year law professor to the journal was rejected. And I thought it was really good. Other things that I've submitted that I didn't think were going to be accepted turned out to be the most cited articles I've ever written. So I'm a completely bad judge about what is going to be not necessarily a great article, but at least a popular article and one that has some influence. And I suppose having an impact is one way that you count greatness. And when you can write an article that results in a change in something that you wrote about because you thought it was a problem, personally at least you'll feel as though it was a successful law review article. And that, I guess, is my main recommendation about topics, is to pick something that comes to you because it bothers you. Something that you feel needs correcting or changing, or you see as an issue that needs to be addressed and nobody's looking at it. Something that really sets you on fire. Because if you're not interested in the article, it's probably going to come through when people are reading it. So if you find something that really sets you on fire, you're going to write a better article probably as a result of that. Some of the pitfalls, there is a tendency, particularly with younger writers, to spend an inordinate amount of time setting the background for the article, background that most people will already know. So if you're submitting to the journal, most of the audience is going to be familiar with sort of basic concepts of international law. And so it isn't necessary to go through the entire history of human rights if you're going to write about some current issue. The really hard part, I think, is getting the balance between breadth and depth, knowing when something is a narrow enough topic that you can do it in an appropriate length article. In other words, you can't take the whole journal for one article, but is also broad enough that it'll be of interest to more than you and your family. And that's the tough part, is getting that particular topic. And you won't always know when you go into it. Something that will look like a really narrow topic can really end up exploding into something large. Something that looks fairly broad can end up being a dead end, because when you do your literature search, you find that other people thought it was a great topic too, and it's been written out. So those would be, I think, my main recommendations that you try to find this intermediate position. Now, where do you look for topics that are going to set you on fire? A really good place to look are at the judgments of international tribunals, because boy, some of them get it wrong, including my commission. And there will be things that you will see being done repeatedly that you think this really needs to be addressed. We do respond to scholarship. And I know I was one of the leading critics of the commission before I went on the commission, and now I get to put in place some of the things I criticize them for doing, but I'm sure we're making more mistakes along the way. And there are things the commission's doing right now that are bothering me a whole lot that I wish people would write about and point out that this is a really bad practice and it's having negative consequences. And I think the more you can tackle primary documents, treaties, resolutions, recommendations, jurisprudence, instead of writing about what somebody else has written, the more innovative, creative, and cutting edge it's going to be, and the better the article will be. So I'll stop there.
Professor Stewart?
I agree with everything that Dinah has just said. Mike, can I borrow your mic? Sure. Thank you. How's that, better? I agree with Dinah. Let me make 3 points, but begin with a question. How many of you here are intending scholars that you're considering writing because you'd like to go into the academy? David, you can, okay. And some of you then are practitioners and looking to just write, okay. That's my point. I think the first point I want to make is there, in my experience, there are two different pathways, two different audiences, if you will. If you write for the practitioners, it's one kind of an article. If you're writing to get a job as a professor or to pursue your academic credentials, I think you, in a sense, are writing for a different audience. And I say that without a great deal of intellectual probity. It's just as a matter of experience. When I was a practitioner, and would go to the literature to look into a topic, mostly it was for information and insight. And the very intellectually oriented theoretical articles were really of, generally speaking, not much use. They were interesting because you would find out what the academy is thinking about. But mostly as a practitioner, I was looking for information. What have people who have more time and have thought about things, what have they said, what have they collected, how can it help me, because I have a deadline, a problem to solve. I need information, I need background, I need collected cases, I need insights into the issue, what can it tell me? So for those of you who are really considering writing articles, I think there are two different modes. If you're writing for the academy, that's one set of audiences and one kind of approach, and if you're writing for the practitioners, it's a different kind of a thing. Now that doesn't mean that something like the American Journal takes only one or the other. It's not true. We do both. And I think many of the journals do both. There's room for both. And some people, like David Caron, can do both. Do the theoretical and the practical. My writing has been mostly in the informational, practical orientation. I struggle with the theory and big words, so let me speak to that. I think Dinah's, in terms of topic, I think that's critical, and Dinah's put her finger on it. You need to identify a topic that is timely and current and that will catch people's interest. If you're trying to get published, you got to look at the editors. In the case of the American Journal, that's very experienced people, and it's peer-reviewed, as Dinah has said. So you're talking to a very experienced audience, mostly people who are up on current developments, who are looking for insights. On the other hand, if you're going to be submitting to student journals, you're looking at people who will review things from a different perspective, not so much experience and not so much insight, they might be keyed to something else. I think that looking at current developments like treaty developments, customary international judicial decisions, that is a very good way to get into a topic, but you want something that's going to be timely and that has a reason for being published. I think you want to avoid, by and large, the historical generalized review, this is the lay of the land. There are places for that kind of an article. If you think of, for example, the American Bar Association does year in review. That's extremely useful. It's a collection, but it's not the place for a very insightful, thoughtful, intellectually challenging article. It's here's what's going on. So if you're looking for topics, that's one place to go look about what people are thinking about. But you want something that's cutting edge. You want to give the editors a reason for publishing it. And that's really critical, because if your beginning introduction doesn't state the point of it, it's going to be in the minds of the editors saying, okay, this is maybe interesting, but why? What's the reasoning behind it? So I think in either case you need to have something new to say. Your project, your piece should try to do something, provide an insight, collect information, develop a new theory, criticize the commission, praise the court, consider the consequences. Today, as I'm sure many of you know, pencils are poised, earphones are on, keyboards are at the ready to see what the U.S. government said in Samantar in its brief, which is due today. And this evening there will be scratching and clicking and all kinds of things going on. The airways will be humming to see. Now there's a development that will be quickly written about, I assume, in an insight pretty soon. So you could take a recognized problem and offer a new way to think about it. You could look at an existing problem by showing it's really not that kind of a problem, but a different kind of a problem. You might pull together other issues previously thought to be distinct and show how they have unseen linkages. There are lots of very creative ways to do it, lots of ways in, but I think the topic needs to be timely, interesting, catch the wave kind of thing, rather than, at least in my judgment, the sort of historical. I don't tend to read the, how Plato considered international law articles, because they're not really relevant to what I'm interested in. But that's not to say there's not room for that. There's a lot of room, and there's a lot of people who write that. So you got to, again, consider what your audience is and how to get into it. In terms of structure and style, Dinah has said quite rightly, clarity of writing is key. I tend strongly to, I trip over the I's. I know that's accepted in the academy. I will do this and this. In part one, I show this in part two, and I think that's okay. Where I practiced, the I word was never allowed. In fact, there was a Secretary of State who forbade use of the first person, singular or plural, and in fact eschewed the active voice altogether. He was a general in the Army, which gave us a way of writing memos that was not familiar to many of us. But I think that short, clear sentences, concise writing, good grammar is key to it. And the introduction, I find, is critical. It's not the throwaway piece, it's debate that hooks the people in. If you don't have a clear view, if you're not telling the reader, the editor, what it is you're doing, what you're covering, what your goal is, it's really, I guess a common word would be a turnoff. It just doesn't, it's not singing. Problem I struggle with many times is, do you give the question and the answer up front? Bart, you're a practitioner, and when I was in practice, I was told religiously, state the question, give the answer right up front for the busy partner. So I always inclined to, here's what I'm going to write about, and this is what I'm going to say. But in the academy, maybe you want to be a little bit more teasing, and so let them go to the, so an editor says, all right, that's your question, I don't see the answer, and flip right to the conclusion where you want to give it. But have a roadmap, have a clear organization, and try to write crisply and cleanly. Okay, let me talk about footnotes for a minute. We all know that the great scholarly articles have gazillions of footnotes. The ones that were in the invitation to this panel actually had, there were some of them that were very sparsely footnoted, and I thought that was good. The law students tend to love footnotes, and that's great. And we know some people who, a good law journal article is one in which there's only at least one page that has no text and is nothing but footnotes. For a practitioner, that can be very useful because there's a lot of information in it. It keys you to things that you might not know. On the other hand, it is for me what the I word is for you. I sort of get, okay. But there are choices to be made there. So I think I've talked about the audience, the topics, and the writing, the structure. Let me just say length, I think, is not necessarily, long length, a lot of length is not necessarily better. Among the articles that were distributed, some of them, editorial comments, were quite short, very pithy, sparsely footnoted, but really interesting to read. And they delivered a message. So that kind of writing can be very good. For the practitioner, length is a negative. You want something that a busy person can pick up and read and say, okay, this is really, I can use this. This is informative, useful, sets out maybe it supports my viewpoint, maybe it doesn't, but it's either way useful. I wanted to put on the table, finally, just a question of publishing tactics, because it's something I get asked about by students, and I don't know the answer. Maybe, Julie, you can, but maybe we're going to talk about this one. There are something on the order of 550 law journals in the United States, right? Somewhere on this.
Right.
Is that about right?
Yes.
Which is an awesome number. I think generally they come in two kinds. There are the general law journals, the Harvard Law Journal, which are prestigious and get a wider point of view, but they're not specialty journals. So if you're considering writing for that, you have to take into account that you're in a lot of traffic, a lot of competition, but the editors may not be specialized in international law. And that can be a factor to consider. On the other hand, there are now lots of specialized international law journals. Again, the student-edited ones are maybe a little easier, but your editors aren't going to be familiar, particularly if you're writing in a very current subject. They're not going to know. As Dinah has said, for something like the American Journal or some of the other very specialized journals where there is more peer review, you're talking to a different crowd. So I'd be interested to know, some of you have had to go down this road, about how you choose, what's your recommendation. I'm told that this Espresso outfit, which you're going to talk about, which is an electronic way, has its benefits and its shortcomings. And one piece of advice that folks I've heard give is be really careful with the details on Espresso. You want to have it absolutely pinned down before you send it out. You want it to have clean text, not rough draft. You want it to be, is that, all right, you're going to talk to that.
No.
So the last question might be, how do you handle timing? If you send it out to some percentage of those 550 law journals, how are you going to deal with the fact that you get 10 acceptances, or maybe you get one immediately? This actually happened this morning. A student of mine sent them out yesterday to about 30 journals and got one acceptance right away. And you know what the problem is. It's not the one that she would really like to publish in. So do you take the first bite, or do you wait for the fifth, or so on? And maybe some of you have some insights into that. I don't know what the answer is. Julie.
Oh, great. I agree with everything they've just said. I used to teach a class called Introduction to Scholarly Note Writing when I was at Georgetown University Law Center, so I love handouts. So bear with me. A few things, I didn't know whether the audience would be well-versed in publishing, but I figured that this would be at least a good place to start. When I taught this class, Introduction to Scholarly Note Writing, I did use this textbook. It is fabulous. It's written by a professor at UCLA Law School named Eugene Volek. But it's available in most law school libraries, so I would definitely recommend it. It's sort of like a step-by-step how to submit, how to choose a topic, and eventually how to publish it. There's a similar book by Elizabeth Fagins and Mary Falk with a similar gist, but also well worth looking at, and also sets out a scheme for not only writing but also publishing scholarly work. Couple things. Moving on just briefly to submissions. One of the questions that face most authors is where to send a manuscript. And there is a website run by Washington and Lee School of Law, which is called Law Journal Rankings. But on this website, what happens is not only are all the law journals listed, so you get to see what your choices might be, but you can also do searches through this database if you want to submit only to international law journals. You can type in keywords. It will say international law, press a magic button, and then it'll give you a list of all the international law journals. What is also interesting, and I copied this page from the website, this first listing, is that not only does it provide you with the information about the journal, but it also tells you how to submit your article. So, for example, this first listing, it says if you should submit articles by email. It gives my name, although I'm no longer managing editor, but at least you can see the address, and it tells you accepts email submission, and it is a refereed journal. Also, finally, at the end, the email address to use. But it has this sort of information for all of the journals listed on the site. It will also provide rankings. So if you submit an article and are accepted by 10 different journals, it will rank the journals according to various factors, but well worth looking into, that if the first journal that gives you a yes back is in fact the top-rated international law journal, then I would say go ahead and accept and make sure you alert the other 9 of your choice. But you can have some sort of ranking system, ultimately computer generated, but it'll give you some thoughts or information to consider when you are undergoing the selection process, as well as the original submissions process. Another thing to consider is the Espresso delivery system. It has a listing of the 550 journals that are signed up to receive Espresso submissions. And I listed the website there. If you go there, it will give you the list of the 550 journals that subscribe to Espresso. Unfortunately, for most of you, there is a charge associated with using the Espresso. You upload your article. Oftentimes, you will also upload a CV as well as an abstract and a cover letter, should you choose. And this Espresso system has computer links to the accepting portions of law schools and other journals that will get your article to those places. Finally, the last place that I listed, if you are really desperate and you are wondering, you know, I wish I knew some journals that would be interested in my article, by all means look at, I think it's table 13 in the Blue Book. There's a list of journals there. It's just a really easy, handy-dandy reference, and you may have a Blue Book in your office. So by all means, that was the last sort of check there as well. The back page of this handout is just the current submission policy for the American Journal of International Law. In part, it says, the American Journal of International Law invites submissions of manuscripts on international law subjects. Its primary focus is on questions of public international law, including closely related issues of domestic law. It generally does not publish manuscripts focused on private or commercial law or on comparative or foreign law, including the internal law of the European Union. Why I am reading this to you is that when you identify journals that might be a good place to publish your article, make sure you also do a little bit of research about the journal to make sure, in fact, that it is a good place to submit your piece to. One of my favorites from about 1.5 years ago is an author submitted a piece on pregnancy rates in California. It had nothing to do with international law. I was convinced it came through Espresso. I was convinced there must be a select all button, which would have allowed the pregnancy rates in California. There was not a mention of international law through, I think, the 50-page article. It obviously was a mistake, but the mistake meant not only that we logged it in and processed it, but it also then went to the editors-in-chief for their consideration. The bottom line is, we're not going to print an article on pregnancy rates in California. It just doesn't fit in the confines of our journal acceptance. I think Professor Stewart mentioned that he thinks the introduction is really important. I also think the title of your piece is crucial. It doesn't mean it has to be perfect, but it should give a very good overview about the focus of your piece. Other things to consider. Let me just look briefly at my note. When you are writing, you need to consider, when you have your piece finished, does it meet the requirements of the journal? How long is it? If it's 460 pages, it's too long. AJIL sets out that it needs to be 100 pages double-spaced or fewer. Please don't send in the 460-page article and say, I see it's a bit long, but I know that something in there is good. No, 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 no. You need to have it in the format we need it in before you send it off. We are really good editors, but none of us have the time to cut it down to that sort of page problem. What else? Oh, another thought, though, is when you are a law student or when you are very eager to publish, you probably, over the course of your law school career or your current practice, you start writing and you probably have some articles that you now have lined up and you'd like to submit. There is one author in particular that everything under the sun that he's ever written, he sends to us. And I think it's like entering the lottery multiple times, that the more entries he has, the greater his odds are of winning. But they're not, because what it looks like from my perspective, as well as other editors' perspectives, is that he really hasn't written anything quality. He's just hoping that he thinks that this is a lottery game, but it's not, it's not, it's not. So please make it your best work. Be particular in choosing AJIL or whatever journal it is, but submit something that you think is meaningful, not everything under the sun. For your background knowledge, AJIL had about 800 submissions that it received in 2010, and I believe it published 7 of those. So the odds are very slim, small, that your article would be selected for AJIL. But if it is, keep in mind a couple things. If the editors who have reviewed your piece request changes or consideration of certain factors, do your best to respond to those comments. They aren't done to make it longer. They're not done because they think the analysis is bad. They are done so that there is some clarification provided. After the original edits and feedback is taken care of, and then it becomes, say, a line editing project, and you are assigned to an editor to work with, do your best to listen to the questions that your line editors have. If I'm editing your piece, and I don't focus on lead articles, but some of the smaller ones, I don't get any credit for editing your piece. You'll get all the credit, but I am trying to give you as much feedback as I can. I am separate eyes for you to say, I didn't understand this, or I think this could be clearer, or I think we could reorganize this so your points are laid out as 1, 2, 3, but instead it seems like you jump around a lot, and I'll say that really nicely. But it seems like you're jumping around, and it would be much better if we reordered it, in this fashion, and I don't think you need to say the same thing 17 times using different words. I really did get it the first time. Finally, one of a really good summary that ultimately the Volek book suggests if you pick up a copy, that how to write a great law article. And this is Professor Volek's advice, that good scholarship should make, and there are 6 factors. 1 is a claim that is novel. That's the second factor. Novel, non-obvious, useful, sound, and seen by the reader as novel, non-obvious, useful, and sound. And in that summary, it occurred to me that ultimately the articles that were selected for review today met that overview extremely well. And so I thought that that would be a good concluding point.
Great. Thanks very much. Before we turn to questions from you, I just have one overall question, which is, you mentioned that the topic should be timely and relevant to people. And my question is, how do you stay current with all the articles that are being published, all the information out there? Because it's obviously not only American law journals, but there are non-American law journals which are relevant. Do you just sort of, obviously at this stage of your careers, you have all sorts of networks, all sorts of sources of information where this stuff comes up, but how do you develop that so that you know, when I clerked at the International Court of Justice, one judge asked us this, you know, how do you just process the sheer amount of information that's out there? And so if you have any, other than speed reading, which Professor Shelton and I discussed before, but
I have to say, quite honestly, I don't think I have ever written a law review article in response to a law review article. I don't get my topics from pre-existing scholarship in general. Now, the piece I did on normative hierarchy, I did go back to the, you know, the classic articles that had been written on that. But I came into that article because courts were starting to talk about jus codens, and I wanted to see, you know, what they were saying and how this fit into all the doctrines on normative hierarchy, et cetera. So my students know I get my exam questions out of the newspaper, and I get a lot of topics out of the newspaper. I mean, one of the things I've been churning around in my head over the last couple of weeks is two issues. One, given what happened in Thailand, what's now happened in Egypt, are we going to develop a doctrine of good military coups? You know, where military takeovers don't fit the paradigm of being the awful, evil seizures of power that they've been classified as in the past. In the African Union, Egypt is now supposed to be expelled because it's had an extra constitutional taking of power. What does that mean? So, you know, that's one issue that came up. The other is, what is the change in Tunisia and Egypt and wherever else it might be taking place? What's this going to mean for the future of the the Arab Human Rights Commission that just has started functioning last year? And nobody predicted anything great for it. So, I mean, those things just sort of come to mind in looking at this. And so in a way, I go to the scholarship once I've got the topic. I don't use the scholarship to get the topic.
Bart, I think that's an excellent question, and it serves to it reminds me to make two other points. Number one, it really is important not to be U.S.-centric. If you're not fluent in other languages, you're a little bit hampered in being able to keep up with scholarship from other countries, but there are ways to do it. But in the area of international law, a lot of the important things are published in just a few languages and a number of journals. I routinely look at the European law journals in particular now. And if your library has some good research folks who can compile these things for you, Georgetown does, that's one way to do it. There are other less sophisticated ways. I tend to use Google Reader sometimes. If you put in a term, it kicks out interesting developments. But you know, I'm sure some of you have more sophisticated ways of doing that. But it serves to emphasize the comparative element, and that's something I did want to emphasize. So the time is long gone when someone in the United States, for example, can write about international law just from the U.S. point of view. It really hampers your literature. And when I look at articles, student papers and articles now, I'm really drawn to say, have you looked at what the European community has done? Are you looking at what the OAS is doing? Can you look at the Spanish literature, or even in some cases more difficult languages, Russian, Arabic, Chinese, whatever? Because there are folks talking about these things, a lot of very sophisticated lawyers considering these things. So you need to access that information and provide that broader instrument. Keeping up with developments in the ICJ and the International Criminal Court, not all that difficult, depending on the level of detail you want to get into. But if you're in an area like human rights, you've got a vast amount of development and literature coming out, and not just from the treaty bodies or the commissions or the European Court, but domestic courts around the world are developing this. So it can be a real challenge. And when I look at articles and papers, I'm increasingly looking for that non-U.S. comparative transnational dimension, because I think that's really a critical thing.
Well, one thing I'm keeping up, and this doesn't apply so much to articles, but articles grow out of it, you'll see that almost all books have co-authors, and co-authors are very useful for filling in the gaps on the things you can't keep up with. And, you know, Tom and David and I really shared the burden when it came to the nutshell for that reason. One thing Julie alluded to, but neither David or I really focused on, and I wanted to mention it, is organization in the article. It's something that not a lot of really, really great law review articles and good law review articles don't start out that way, because a lot of good scholars, their brain works faster than their typing, and so you end up with something that is almost stream of consciousness. And it's part of knowing your own weakness to know when you need to really set it aside, do something else, come back and look at it and see if it makes any sense on a second reading. Because the organization, having the roadmap and following that roadmap is really, really important for the readers in determining the quality of the article.
Let's open it up.
Beth?
Yes.
Two questions. One, I wonder if you could speak specifically in the context of the journal to international decisions and book reviews. A lot of young authors, I think, sometimes get a start contributing those kinds of pieces, and how would you suggest going about that? And then another unrelated question, but how has the blogosphere affected the way you think about these issues? Keeping abreast of things that are hot or current, and judging whether your idea has been preempted, so that people can put things in a blog and then doesn't mean you can't write about it in a longer scholarly piece.
I could probably talk as to the international decisions and the book reviews. For the international decisions, if something crosses your desk, a decision was just released by a foreign court, you think it sounds interesting, it's also the final judgment from that court, because for the most part, we do not publish the interim decisions of international courts. But you should contact David Biederman about your interest in preparing an international decision, quote-unquote, international decision about this international case. It usually comes in as 12 double-spaced pages. He can provide you the format requirements, but half of the piece will be devoted to giving background about this new case, and then the second half is devoted to providing some insights about that case. But a very good way to get published in the journal. Book reviews are also a good way to get started. However, for the most part, book reviews are done by invitation only, of Richard Bilder, who is the editor of the book review section.
But sometimes he will contact members of the board
Yes.
like me, and he'll say, I just got this last week. I just got a new book on human trafficking. Can you suggest some people who would be good to do the book review? So, you know, if you have areas you're interested in, you know members of the board, let them know that you'd be interested in doing that. It's also a good way to build your library.
Yep.
If nobody else is going to talk about the blogosphere, I will talk about it because I'm a new traveler into the blogosphere, and it can be overwhelming, the number of blogs. Again, Google is easy for me, so I go to that, and it lets you select a number, particularly in the area of international comparative law. It's fairly easy, and it gives you a daily feed. I'm sure some of you are much more sophisticated. Makes it's difficult to keep up with all of the things that people are writing on. It's an excellent way to stay current with developments. I find it challenging to read everything that everybody's writing about. Sometimes it's enough to know that a decision has happened or a development has happened. Sometimes you find a particular analysis to be really challenging or interesting or infuriating or whatever. There's a lot of opinion. But it's a source of information. I don't think, though, Betsy, that the fact that there's been a blog on it preempts you from writing something more thoughtful. Obviously, blogs tend to be done very quickly, and they tend to be short half-life. But it might alert you to a topic that's worth doing a more in-depth analysis. But I would imagine folks in the audience have much more experience. Is it a way that you use to keep up with current developments, any of you? David, are you a blogger?
I don't blog. It does strike me that it relates to what Wallach wrote about novelty. That, and I don't remember where the quote is from, but in a way, what do we really value in some of this? And it's who's first, in a way. It's not, brilliance is key, but clarity is key, but novelty is all about that first article that says it rather than the second. And so I don't know if the blog somehow changes that dynamic of what happens. But there is a timeliness. Certain things certain articles just hit
One is, would you say that there are certain areas of international law scholarship that are oversubscribed? Because at least talking about blogs, and one of the huge blog commentary a few months ago was about how international criminal law, for instance, is oversubscribed, and how that affects perhaps even publishing decisions for not only the AJIL, but especially student-run journals when they're considering which pieces to consider or not from rookie authors especially. And the second is that I noticed when you were reading out the statement, Julie, about how the journal generally does not publish manuscripts focused on comparative or foreign law. And I was wondering how you would describe that remit, because especially if one takes into account sources in other languages when trying to build a case for some issue of international law. Like international criminal law, I think, is particularly susceptible to that when you're drawing upon Spanish or German or French sources even to try and build something for international criminal law.
No, to bring in examples from different jurisdictions, absolutely fine. But in my experience, the journal is not going to publish on a comparative piece like United States law versus Japanese law. So to have it divided, does that make more sense now?
Sure, because it's just a new area of scholarship, especially a large part of the piece may in fact be comparative, because that's where you're drawing from, like that's your primary source material in some ways, so 90% of the piece may in fact be comparative.
But is the focus more on the international component, or is it more on the comparative component? And so that will be part of the weighing of those factors.
But that may be particular to the American Journal. It's a particular orientation, and you may have an issue. Let's take a hypothetical issue where there's a division in approach, a very clear distinction between two legal systems. And that may suggest to you that this is an area that needs some attention at the international level, some sort of bridging mechanism, maybe a declaration, maybe a treaty, maybe some sort of entente. So you could take a comparative basis and build a proposal that this is something that needs attention at, let's say, at a global or regional level. So you can do that, and that may be not something that the American Journal would be interested in, but you might find 5 other journals that say, no, that's really interesting. I think that the comparative element is really underappreciated by many people who publish, and I think it's an important aspect. It informs people, and you know, it's not just the English language speakers that are driving developments in international law. So it really behooves us as practitioners and scholars to reach out and add that element, because the world is changing. To come to the other point about new issues, the rapidity of change in international law is just phenomenal. I've been in the area for a number of years, and it used to be you could spot an issue coming and you'd have a year or 2 or 3 to write about it. Now it's just, things come and go very quickly. The trick, a lot of things that, questions that I get asked by students, what should I focus on, involve looking ahead 5 years. What are going to be the 2 or 3 areas of practice or intellectually challenging issues that folks could start to write on? So human rights is, I think, a pretty crowded field right now. International criminal law 10 years ago was terrific. Now everybody's doing it. There are a number of others. Intellectual property would be on my radar screen as something coming down the pike. Others may have other things. So if you're looking ahead, just in trying to figure out what might be good things to focus on.
And sometimes, you know, you'll read a decision and you'll think it's interesting, and it's just one decision, so maybe write it up in the international decisions. But then another tribunal does something on a similar topic, and suddenly you think, in vitro fertilization and embryonic rights. This is something that hasn't been written about yet, and here it's coming up in different tribunals. So leads into a whole new area of bioethics, regulation, of biotechnology, and not just of genetically modified crops, but all kinds of bioethics issues that are coming up at the international level now. The broad answer to your question, are some areas getting oversubscribed and others being ignored? Yes. I mean, I see it with students who come and want to write about certain topics, and half of them are always international criminal law. It's like, enough already, you know, there aren't enough cases to justify it.
In the back.
In the recent journals or recent issues of AJIL, I've noticed a tendency to go for very, very long kind of magnum opus articles. noticed this trend, or it just seems to, I've just kind of caught on to it, or, because some of the, it seems like they're going for extent of, very large articles as opposed to more kind of sharper, more cutting.
Well, I think two things that I think have happened in the journal over the last decade, and it tends to wane and ebb, or ebb and flow, or whatever the simile is. But one is, and this is true of law publishing generally, more interdisciplinary work. And that tends to lead to larger pieces because you are dealing with more than one discipline. The other is empirical. And so you put all those tables in, and again, it makes it longer. You put the two together, interdisciplinary empirical work, and you end up with very major articles. And I think that explains a lot of what you're seeing. And it's not just in the AJIL, it's throughout law publishing.
I think there's also, I just read, this is from my law school days, but I read about the length of Supreme Court opinions now versus, say, 100 years ago before the onset of the computer. And decisions used to be really short because manpower was limited and it was hard to typeset that sort of thing. And now with the advent of the computer and how quick word processing is and how fast the files can be and how fast you can generate and check them and edit them and format them all in, a split second, it has ultimately increased the length of scholarship, judicial opinions, whatever it might be.
I have a question on the empirical and interdisciplinary nature of some of the articles. To what extent do you reference some of the sources in the other disciplines? I mean, if it's an article heavily based on economics, do you actually have someone else peer review it who is very well versed in the economics, or is it if it sort of seems to make common sense, we'll accept it? To what extent is there rigorous review of some of the claims that are made in an interdisciplinary approach?
I would never write an economics article. But the answer is, yes, you do go for that outside peer review when necessary, and certainly as an author. I do cross-reference a lot of biology work, and I'm very lucky my son is a professor of biology, and so I have him check everything I do that has to do with human evolution, biology, and anything that is in the field that is related to that. And I think that's critical to be done, because you've got to have that verification that what you're saying has some basis in the literature.
Can I just, I don't know the answer to this, but let me ask you, Dinah, if you're writing more for the academic side rather than the practitioner side, having an interdisciplinary approach, I would think is a good thing.
Yes.
But the important thing would be to identify the approach clearly that you're going to take some point early in the article. Set out your formula, your approach. And I think that you read on a number of excellent and very intriguing articles, which take a new look at an established area, but from a different perspective. But I think it's always very important to say this is in one fashion or another, I'm coming at this from rational choice or law and economics or whatever it is, scientific.
The law and has become the really hot thing in terms of getting into academia now. Everybody's looking for the PhD or the equivalent in some other discipline. Certainly at the top law schools, they all want to see now a double degree.
Right. And just to come back to my first point, from the practitioner's point of view, at least from where I was practicing, that's really that's interesting but not really helpful, because you're not really interested in the law and approach. You're interested in what is the law, what are the dimensions, what are the developments. So that's why one thing was behind my advice about considering the particular audience. I come back for one quick comment to your point about the title, which I think is absolutely right. I find that very challenging to get a title which is catchy, intriguing, but tells you what the article is about. I'm sure you've all had to do literature sources. I'm looking for something on the X problem, and what you're going to do is be looking at that title. So you may, if the title is uninformative, you may go by the one piece that really is going to have the information that you want or the insight that you need. On the other hand, a dull title probably doesn't get you excited. It looks like it's a purely descriptive item when there's something. So there's an art to it. I haven't mastered that art. I can tell you I wrote one article which I thought had a really interesting title to it. I've monitored the times when it's been cited by other articles, and about 60% it's cited for the opposite proposition that the article said. And I trace that to an inept title. It didn't suggest the particular, it gave the topic, but didn't suggest the right orientation. So most times when it's cited in a footnote, it's for the wrong proposition. Really annoying, but interesting.
On that point, as practitioners, to what extent, in terms of the amount of time as a percentage of your overall time as practitioners, do you actually reference academic work? And from that, you know, when was your perspective actually changed on the basis of what was expressed in the international law article or book? I mean, you might reference articles for information, as you mentioned, Professor Stewart, but to what extent were you actually persuaded that of the author's opinion, so that, you know, that piece is actually useful and changes things?
Trying to think of a specific example. Maybe your article on justiciability of economic and social rights.
That gets people irritated a lot.
Yeah. But it changed some minds, I think.
Maybe. In the particular area, I practiced in the government, so we didn't actually cite a lot of law journal articles, because most of the policy people aren't interested in that. It makes it look like it's, well, they're not, so that doesn't really help. If you're writing an internal memo, lawyer to lawyer, then it's more important. I won't speak to judges, you would know that, probably more important. We work in an area in which the journal writing is actually, I think, more important in the area of international law than it is in many other areas of practice. And some of the, I mean, if you're going to cite Professor Shelton on human rights, that's a very powerful citation, and people recognize it, and they give it weight. I think for analyticals, I was just really trying to say at the outset that for practicing lawyers, you're looking more for information than you are from some new theoretical insight. But that, if you're writing for the academy and in a more theoretical setting, the opposite is true. So I think that they have more weight there.
We had a case this summer in which the commission was split over a particular issue, and it's going to the court now. But I ended up writing the dissent, and I did go out and review the literature and cited articles in it to try to persuade a fourth colleague on the commission to join the dissent. Didn't succeed, but I did get 2 others, so we're 4-3. But I think in a case like, you know, we have such a heavy caseload, we don't always have the time to go out and read the law review articles, and a lot of our cases are pretty straightforward cases, you know, extrajudicial killings and torture, where we get novel issues that we haven't had a chance to explore before. That's when it really becomes useful for us, and we do go out and read the articles then.
One more question from?
I would just say from a practitioner's viewpoint, because I do practice, I say, yeah, basically what I would look for in a law review article is generally, is there a lot of facts and materials that I can mine out of it? You know, that I don't really care about, and this goes to the blogging thing about some Furgerson member's viewpoint on, like, what's so cool about going on with international criminal law? I really don't care what that person's opinion is, unless that person's like a retired judge of the court or a 30-year professor. I mean, then I'm never going to club. But I think someone who has a very well-researched, deep footnoting, going back to footnoting, then at least it shows that they really thought about it in a mature, calm, detached way, and not just trying to make a name for themselves with a flash.
Sometimes you find folks who write articles that are addressed to a problem area that ought to be taken up. I've done one, for example, on electronic service of process, which is now coming in domestic practice here in the United States and in a few other countries, but not in many civil law countries where there's real resistance. So we did an article saying, here's the problem, it's coming. You can hear the herd, the thundering of the herd. It's time to get on board. Here are some principles that the international community ought to adopt. I thought that was really relevant, insightful, futuristic, a real contribution. Dead. Just like, what?
Yeah. But-
So every so often, I think about resuscitating it, maybe the timing was wrong. It was obviously such a good idea that people would have to.
Yeah.
So,
But there's also, I think, a useful amount of cross-fertilization that can go on between the practitioners and the academics who are writing. I mean, my most cited article is one where I was actually asked by lawyers who were involved in a case at the ICJ to write the article to soften up the ICJ for something they wanted to do, which was to have the ICJ accept amicus briefs on this particular case, because the lawyers for one of the countries didn't want to make an argument, but they wanted that argument made by somebody. And so I wrote the lead article for the Journal on the role of amicus curiae before international tribunals, and nobody had ever written it before. But it directly came from the request of a practitioner.
Well, great. I know Professor Shelton has
Yeah, I have to go teach.
run off to class to build the new scholars and writers
Right.
and practitioners. Thanks everyone for coming and thank you for participating. If you have any other questions, I think Professor Stewart and Furgerson will be here for a few more minutes so we can talk after the session. Thanks very much.
thank you, Brett.